Thanks very much for joining today. Today is an information governance update, so an update on all things data protection and freedom of information. My name is Vicky Bowles. I'm a partner in the commercial team at BWV, but I specialise in all things information law, so that's all I do every day. And I'll just talk you through what we're going to talk about today. So some trends in sort of requests and ICO enforcement, just so that you can see what's going on at the moment. Data protection issues in cyber attacks, a little bit on procurement and data protection, something on gateways for research, and then finally, well, I was going to do an update on the new bill. It's been shelved for a while. We don't know when it's coming back, so that's slightly less useful now, but I'll just do a very brief overview of that. The reason I've chosen those particular topics are because they are the ones that I'm currently getting questions about from my clients in local authorities. So I'm assuming that these are issues that are coming up for you on a fairly regular basis. So those are the ones I'm going to concentrate on. So trends in requests and ICO enforcement. We are not just in local government, but across the board, we're seeing subject access requests being used in the context of grievances and dismissals. That's fairly standard, and as I said, applies to all organisations. That is so, and they tend to be used during the course of the grievance, which makes it very difficult, because what you usually have is you're going through your process, so it's a complaint or it's a grievance or whatever it is, and then the individual makes a subject access request, and actually some of the information that you're gathering is personal data, but it's also collected or being used for the purposes of that process, and it could prejudice that process if it was released. There is an exemption for that. But then you also have to think about, well, actually, if we withhold it now, we might be disclosing this information in 3 weeks' time. So is it worth holding it back? So it's always worth considering that context if you are running those parallel procedures. But I don't think it's something that's going to go away, unfortunately. I think we just have to live with it. In terms of the ICO, I think I spoke about this last time. The Ministry of Justice are still behind on their subject access requests. They have 7,753 outstanding SARs as of last month, when the ICO issued this notice, and they've now been told that they have to deal with them by December, and if they don't, that's potentially contempt of court. I think this is an enforcement notice, so it's just interesting to see how that plays out. I do feel sorry for the Ministry of Justice. Obviously they've got that many to try and go through, and how on earth you resource that, I don't know, but there's the threshold for ICO involvement. So if you've got a backlog of less than 7,700, you might be okay. A few decisions that sort of piqued my interest for this particular sector. There was a decision in relation to Liverpool City Council, where they had been asked for, these are FOI decisions, they'd been asked for a copy of an audit report that had been carried out into, I think it was a community interest company that the council had been supporting, so there was some funding that they provided. The council refused to release the audit report, and they used section 36, so prejudice the effective conduct of public affairs, and the ICO found that that was engaged, so that exemption did apply to the report, but the public interest tipped in favour of disclosure, and that's the bit that's quite important. So it's not just because section 36 is one of those qualified exemptions, it's not enough that it actually is covered by that. You then have to do that public interest test, and I think here the reason it tipped in favour is because the report was all about public funds and where those funds had gone, so the public interest and in the transparency of that is really important. So that's why that tipped in favour of release. Just a reminder really on planning. If you get requests that relate to anything to do with planning applications, those have to be dealt with under the Environmental Information Regulations and not the Freedom of Information Act. So the Environmental Information Regulations are broadly similar to, but not quite the same as FOI. So it works the same, as in you make a request for environmental information, you're entitled to see it unless it's covered by an exemption, but the exemptions are slightly different. So it's just a reminder to be aware that the environmental information regulations do exist. They don't come across my desk very often at all. I think I've done work on 2 or 3 requests in the last sort of 3 years. But they do come up occasionally, and quite often authorities get tripped up because they forget that actually it's which regime it is. Most of the time the information is still exempt, but you've got to find the right exemption. And then another reminder, this was Georgian Parish Council, so a much smaller authority, but they had been asked for details of how they handled prior notice applications that had been submitted by the requester. I'm just checking my notes to make sure I get the right thing there. And that should have been a subject access request and not a freedom of information request. And it doesn't matter what the individual says their request is, you have to deal with it under the regime that it falls under. So if they're asking for their own information and they mention FOI, you still have to deal with it as a SAR. If they're asking for general information and they say it's a SAR, you have to deal with it under FOI. So it's for you to select the appropriate piece of legislation in that circumstance. And just not on the slide because it's fairly new, you may have seen that the ICO issued its first FOI enforcement order in 7 years, and that's against the Department for International Trade, and they also issued a practice recommendation for the Business and Enterprise BIS. I can never remember what that one stands for. So 2 notices. The enforcement notice was issued to the Department of International Trade because 50% of their FOI requests were late and they couldn't give any good reason for it, which is interesting. So the reason they were late were to do with the process that they were operating under, as opposed to the number of requests or the type of requests or the complexity of the requests. So the ICO felt that there's no reason why they should have been late, and so they were ordered to improve their processes and answer their current outstanding ones. And failure to comply with that is actually contempt of court potentially. So this is where the ICO gets sort of serious. With the other department, they were only issued a practice recommendation. So they're in a similar position in that a lot of their requests weren't being answered within time, but they could show that they had a 55% increase in requests in 2020. And that had led to obviously resourcing issues, staffing issues, particularly around that area where people were working from home and all of those things. We were mid-pandemic. So the ICO understood that, so just issued a practice recommendation suggesting that they change some of their procedures, because it wasn't just about the procedure. There was actually, they could demonstrate there was an increase. The ICO also pointed out that the department worked with the ICO, and I think that's quite important. There are, I think Oxford City Council may be in a bit of trouble if they're not careful, because there's a few decisions against them where they're just not answering FOI requests, and that's just not an option. It's a legal requirement to answer, and I think there are rare cases where the risk of answering is higher than the risk of not answering in relation to something very, very sensitive. But they are rare, and actually in the normal course of events, you should be dealing with the requests and answering them as best you can. One of the things that is interesting about those 2 particular cases is actually it's really helpful if you do track the number of requests that you get, so that you can show that in a particular period you had an increase in requests, or for a particular period you had the same number of requests, but staffing levels were reduced because of the pandemic or whatever the reasons are. So it's important to be able to justify it if you are late. And to be honest, lots of local authorities and lots of public sector clients that I work with a lot of their requests are dealt with late, because 20 working days isn't that long. You quite often have to ask colleagues for information, and you have to give them time to collect the information, and you've got to review it, and you've got to get someone else to look at it, and it's not a simple process. But if you can show that you're doing the best you can, the ICO actually isn't concerned if they're a few days late or a week late. I think in these cases it's consistently late for no good reason, so that's the difference there. Next slide, please. So data protection issues in cyber attacks. There has been a slight decrease in the number of recorded cyber incidents. So this is where you're hacked or sent phishing emails, and something around your system is compromised, so your technical system, and it does raise data protection issues, and there's quite often a data protection breach if you have some kind of cyber attack, because it's quite often personal data that is compromised in some way. And the key sort of messages really around this, there is this legal requirement in data protection law to have in place appropriate security measures, and these must be technical and organisational. So someone in the organisation needs to understand what those measures are and how effective they are. And as with everything else in data protection, it's not enough just to have measures in place. You've got to consistently be looking at them, checking them, making sure that they still work. So there are a variety of tests that you can do, and you can do them internally, or you can get external organisations to come in and test your systems. And unfortunately, that's one of those areas where it's completely unregulated. So you will have some organisations that are very good and some that are less good and are trying to sell you a product, and you don't necessarily know that. So it's quite difficult with the external. But there are things you can do internally to test systems and see how they work. And it's not just about the firewalls and the VPNs and the things that sit around your system that I don't understand, because I'm a data protection lawyer and not an IT expert. It's also the internal controls you have. So the organizational controls, like access controls, for example. So do you test regularly that you've got them in place, but if you have got them in place, do they work? So if you've shut off HR systems are quite commonly restricted only to your HR team. Does that work, or is there a hole in the system or a gap that needs to be plugged? So how do you make sure that those access controls are actually in place and do work? Training is really important, and I can't stress that enough, really, because if you do have a data breach and you have to report it to the ICO, one of the questions is, when were the staff last trained and what were they trained on? So you need to be able to show that staff have been given the opportunity to understand what they need to do in order to keep data safe. And it needs to be, so you need to do the training, but you also need to have some sort of records to show that staff have attended the training and ideally understood the training as well, because we all know that you can turn up to sessions and people switch off and they don't listen, and data protection isn't the most exciting topic. I am aware of that. So how do you know that the people sat in front of you or whoever you brought in to do the training do actually understand what they need to do in their role? The most common way to do it, and the way that our training providers do it for the courses that we have to do at VWV, is to have a multiple choice test at the end, 10 questions, and you have to answer them to see. I did get one of our GDPR questions wrong, I will admit that, but I still maintain that it was one of those questions where if you have a bit, it was one of those it depends questions, and it wasn't as clear as they were trying to make out, but yeah, 9 out of 10 is a good score. That's fine, I still passed, so it's all okay. Still got my job, thankfully. But yeah, so can you demonstrate that not only have people had the training, but they've actually understood the training? And also chase up those that don't attend, and that's often the gap that is missed. And the ICO they've released an accountability toolkit, which you can go through to work out if your organisation is complying with the accountability principle. And one of the things they're very keen on with the training, and I think it's mentioned more than once, is it's not just enough to offer the training, it's making sure that everyone's attended the training, and if they haven't, do they get the opportunity? Is it just left until next year, or does somebody go and speak to them or rerun the course, or how does that actually work? So how those, it's not necessarily always the case that you have to make them sit down and do the training the next week or whatever, but are you aware of who's attended, and what do you do in the case of those people who haven't? Another common risk area in relation to cyber attacks, and I think was the cause of one of the biggest ones. It was the Dutch company, the name now escapes me. We all work on systems, and we have a number of different systems that are all talking to each other. So I have Outlook, and I have Office, and I have Teams, and I'm on Zoom. You know, so there's all these different applications sat there, and they talk to each other, which is great because it means that everything is seamless and it works. But that there is also then a risk that if one is compromised, it's then easy to get into the next one and the next one and the next one. So you might think that one application that you're using, the data is low risk, or there's no personal data in it, so it doesn't matter. But if that application talks to another one, then cyber criminals can get into the low risk one because you haven't put up the barriers, and once they're in there, they can then get to other places. So that's about making, not necessarily for the people on this call, but it's for the organisation to make sure that those things are considered, and again, those holes are plugged. I've mentioned systems testing for vulnerabilities, but the final point to make is around your risk register, and are data protection risks on that risk register. Organisations do risk registers in very different ways, and the guidance on how best to do them changes frequently. I'm a governor at a local school, and the risk registers gone from a sort of 5-page spreadsheet to we've now got 6 or 7 different risk registers for different areas, and data protection sits in all of them, I think most of them, in slightly different contexts. So is it something that you've recognised? And again, as with all risks, it's great if you've registered it and you've logged it and you know it's a risk, but actually what are you doing about it? And again, it's fine to not do something because there are some risks that you cannot mitigate. So an employee being human, for example, and making an error, you cannot mitigate against that that end result. You can put in place training and you can make sure people understand, but someone will still have a bad day and press the wrong button and do, you know, send the wrong email or whatever. That happens. You cannot prevent that, but it is a risk, so it needs to be recognised, and you need to put in place the things you can put in place. And if there's nothing you can put in place, then you recognise that and you say in your risk register there are no mitigation factors, but we're aware of the risk, so you know that's as much as you can do, and that will help with the accountability side as well. Have the next slide, please. So procurement and data protection, and I get involved in this quite a lot, and it feels more complicated than it should be in most cases, I'll be honest. If you're doing a procurement process and you're putting in place your documents, you need to understand at the outset, if that's possible, whether or not whatever you're contracting for will require the sharing of personal data. It's likely that it always will, because you will always need to share the details of the person at the council who's responsible for the relationship, for example, and you'll need named individuals at the contractor in order to contact them about issues or whatever it is. But that's fine, that's controller to controller sharing, so we're not concerned about that. But actually, in terms of the project itself, will there be a need to share personal data, or will the contractor be collecting personal data that they're going to share with you, or how is that going to work? So ideally, at the outset, that needs to be understood and worked out. And once you know whether personal data is going to be shared, you then need to look at, well, on what basis is this data sharing happening? So is it, as I've just said, the sharing of contact details for both parties? That's controller to controller sharing, so that's fine, and we don't need to mention that in the agreement if you don't want to. It's no legal requirement to. That's fairly standard. It's low risk. It's usually business email addresses and phone numbers, etc. So that's fine. The complication comes if there's going to be a joint controller relationship, so where you are working with that partner to jointly determine what happens with the data, or if there is a controller processor relationship. So if one of you, it's usually the contractor, but not always, if one of you will be acting as a processor. Because if you've got the joint controller relationship, or you've got the processor relationship, then you need to put those terms in place. And the joint controller position is relatively straightforward in contractual terms. Your contract just needs to have a clause in it that says how you are going to deal with the provision of privacy notice information and data subject rights. In most cases, everyone just does their own and deals with their own bits. You don't necessarily work together, but on closer relationships, you might want to work together, or it might be that the contractor is the entity that's responsible for privacy notices. So you would put that into the agreement. So that's relatively straightforward. With the processor terms, the terms themselves, they're set out in Article 28. We know what those are, we know what they have to be, that's fairly standard. The issue usually comes with the question about sub-processors and how you deal with that, because you have to either give specific authorization or a general written authorization, and there are various rules around that. So what's going to work in this situation, because you don't know who your processor is at the outset of this. So we usually recommend a general written authorization and then have something in place to a practical way of dealing with that. And the data protection particulars are the other key bit that's actually really difficult to do prior to the contract being entered into, and even sometimes at the start of the contract, because things change. They are required under the Article 28 of the UK GDPR, but there are ways of agreeing them after the fact. It's just remembering to agree them after the fact and stick them in a schedule for the document. That's great if you know upfront fairly clearly what the data processing or controller arrangement is going to be. That's not always the case, and I have seen quite a lot of situations where it's just not known because the extent of the project or how the project is going to be carried out in terms of personal data just either hasn't been thought about because it's not the main purpose of the contract, or it's just very complicated and nobody actually knows how it's going to progress. So the key there is trying to future-proof yourself. And the easiest way to do that, in my view, is to say, if the parties are separate data controllers, this clause applies. If the parties are joint controllers, this clause applies. If at any point in the relationship, the parties become a data processor, they will enter into the agreement at schedule whatever, and you enter into that data processing agreement at a later date, at the point at which it becomes apparent that that's what you have to do. Data protection law, that's absolutely fine. You don't even have to put the agreement as a schedule, you can just have an intention to enter into the agreement. I think it's helpful to have that attached so that you've got it ready to go and the parties just need to sign it, and it can all be agreed up front. But it can be a separate standalone document if that's easier, but it just makes it means that then you've got more time to think about it and work out what the correct position is, and you can fill out those data protection particulars. And you can do that even if you're fairly certain what sort of relationship you have and the types of personal data, etc. You can still put that in order to future-proof the arrangement, so if things change. And there are some contracts that you're working on that are obvious and it's clear and everyone knows exactly what's happening, and as I said, there are others, and those tend to be the ones that I get involved with on the fringes, where it's a bit more fluid and it's the start and nobody quite knows where it's going to go, or if we're going to do this or that, or how the contractor is going to do this or that. So yeah, future proofing in case of change can be really helpful, and that's that if this applies, if that applies, and that could be a really helpful way of doing that. Next slide, please. Gateways for research. I'd sort of put this in because the new bill is very keen on opening the gateways for research. So I just wanted to sort of throw this in to say that actually the ability of public authorities to share data for research is quite wide. So there's a lot you can do. So it's possible to share even personal data for research purposes without consent. And there are two things you have to think about. You have to think about the data protection position, but also whether the information is confidential. And the data protection position, for once, is more straightforward because you just have to go through that. Is it fair, transparent, and does it have a legal basis? Most research has a sort of public task legal basis, so that's nice and easy. And there are various, there's section, is it still section 89 in the Data Protection Act that makes processing personal data for purposes of research much easier. The confidentiality side is slightly different, and actually a lot of the personal data that you will deal with about individuals in your area, they will expect a certain level of confidentiality to apply. So if there is a duty of confidence that attaches to the information, so if it is confidential, that's not a bar to it being used for research purposes. You just have to be able to justify the breach. And you justify the breach usually by using the Digital Economy Act, because that allows for research to pass between public authorities. Or you can anonymise it, and that cuts out any issues. If you can anonymise the data, that's brilliant, because then you don't have to worry about confidentiality, you don't have to worry about data protection. But quite often, well, it depends on the research, but usually if an organisation is doing research, they are looking at they want to look at individuals because that's the type of information that's useful. I've been doing some work with some universities on longitudinal studies where they are looking at sort of how, particularly COVID related, but how various economic and other social factors influence people's health, essentially. So useful to that kind of process is information that local authorities hold, like about benefits and about council tax and rubbish collections and all sorts of information, some of which might be publicly available, but some of which you will hold, and they want to use it to attach to an individual to see how those factors are affecting them. And that is, on the whole, it's fine. You've just got to make sure you put in place the right things in order to do that. Next slide, please. So the future of data protection law. Just seen the time and realised I was worried because I had so much to say that I've tried to cram it in. So we'll have plenty of time for questions at the end if you've got any, which is great. So the Data Protection and Digital Information Bill, it had its second reading in the House of Commons, but it's then been a sort of shelved, pause, I don't know what the technical term is. It's been delayed and we don't know when it's coming back. So it's going through that process in Parliament to become an act. before Liz Truss took charge, it was supposed to go through and it was supposed to be a priority. Now it isn't. So I don't know what that means, to be honest. Nobody knows what that means. But if it does go through, and if it goes through as it's currently drafted, which there are no guarantees, the following 4 points are the ones that I think will be most relevant to local authorities. So I will just highlight them for you so that you're aware, and then look out for more updates, I guess. But one of I suppose less actually, one that will be less applicable to you but still worth knowing about is that where you use data, personal data, and you're relying on legitimate interests, the ICO does seem to suggest that you should have done a legitimate interest assessment for every single time you use that. Now, no organisation does that. Most organisations don't do them at all, never mind in the sort of standard cases. But there will be a list of situations in which a legitimate interest is just automatically approved, if you like. So that will be quite helpful. What will be more helpful, hopefully, if it goes through in the right way, is to the aim of the ICO, of the government, was to bring in the vexatious requests exemption under FOI into subject access requests. Because at the moment, the only way in which you can refuse an SAR is if it's manifestly unfounded or excessive. And any of you that have read the guidance will know that that's actually quite a really difficult threshold to meet. So actually, that's not it's not ideal. And I think I've used it twice recently. And once it was refused and the ICO said, no, you have to go back and answer it. I was fairly sure that was going to happen, and it was partly a strategy to buy time as well, if we're being honest. But yeah, so one was refused by the ICO and they said it didn't meet that threshold. However, that particular request would have met the threshold for being vexatious, because it's an individual that's made more than one subject access request, and the context of it was really important. And I think that's key in this, in the subject access regime, where, like, we're talking about people making subject access requests in the course of grievances or complaints because they're trying to get evidence to support their case or whatever they're doing. And in some cases, particularly where there's litigation in contemplation, that's not necessarily appropriate, because they can go and they will get disclosure if they're bringing a claim, and that will give them everything they need, so they don't need to make a subject access request. And I'm sure you've seen the ones where people are, they're making them just because they know how much hassle it causes, and they've got no interest in the information. And hopefully, if we bring in this sort of vexatious request as opposed to manifestly unfounded, we might be able to start weeding the lower level ones out, and should reduce the burden. I mentioned research earlier, so the government is keen for all organisations to share more data for research purposes. I'm not sure whether what they've done in the bill as it stands actually achieves that, practically speaking, because doesn't really address the confidentiality issues, it only addresses the data protection issues, but it gives an indication that this is something that the government is keen on moving forwards. And finally, changes to your Article 30 record. So it's supposed to be less burdensome. The Article 30 record in itself, I think, is burdensome if you carry it out in the way that the ICO, not the ICO, but the UK GDPR suggests, but actually a requirement to have a data map is really helpful. And lots of organisations don't have them, and then they don't know where their data is or who's sharing it, and it's difficult to to find the information you need to make a privacy notice, for example. So actually, I do think there is something to be said for some kind of data map, but not necessarily an Article 30 record, but the requirements are being tweaked. Again, it's supposed to make it less onerous. Of course, it doesn't make it less onerous if you've got an Article 30 record and then you've got to make a new one and it's different, because that's just doubling your admin, which is something the government don't seem to realise when they're trying to make changes to a law that we've all just about got our heads around and got up to speed with, and now they want to tweak it again. But again, it remains to be seen actually what those changes are. They sounded like they were going to be more dramatic in the build-up, but actually they're not so much in the actual text. But again, who knows, because we don't know when it's going to be tabled and we don't know what those debates are going to be.